We'll just do this. Hi, good evening, everybody. Thank you for joining us at this webinar. We're very happy to have Alan and Yasmin from Katten joining us for this webinar, as well as my partner, Rohan George. So we're basically going to be focusing on what has been happening over the last few months, ever since the GDPR implementation date, which was late in May. So without further ado, I'm handing the floor over to Alan. Alan, over.
Thank you very much, and good afternoon to everybody. So what I thought we would do is go through where we are on the GDPR, a little bit about the GDPR to start with, and then intersperse that with some recent enforcement actions. The UK has been very active in this regard, rather oddly because we're coming up to Brexit. But they are, as far as we know, the only regulator to issue any guidance on the GDPR, and also to issue any enforcement actions, apart from the French. The French have issued a couple of enforcement actions. And I think Rowan and Neela are going to jump in with a bit of their experience dealing with Indian clients and compliance with the GDPR. So let me see if I can get this right. You should all be seeing these screens in front of you. So to start, the previous position in Europe, which led to the GDPR, was based on a directive which had indirect effect, which meant that it applied indirectly in each member state. So each member state in Europe, 28 of them, had to have their own data protection laws, which of course were all different. So whereas the basics were the same, there were differences in each member state as to how they implemented and monitored data protection. So with effect from the 25th of May this year, so some almost 6 months ago, the EU General Data Protection Regulation, so notice that it's a regulation and not a directive, came into effect. And regulations in European legal speak have direct effect, which means they apply pretty much in the same way in each of the member states of the European Union. There is some scope for differences. For example, the age of consent can be varied across the Eurozone, and some, but not all, of the member states have implemented their own data protection legislation. So in the UK, we have the UK Data Protection Act 2018. All member states will need to introduce their own legislation, but some are further behind than others. The UK, again, is leading the charge, which is all a little bit depressing, given that we are only going to be in Europe for a few more months. So where does the GDPR apply? It applies regardless of where the processing takes place for EU establishments. What's an EU establishment? Essentially, there's some scope for discussion on this, but if you've got an office or a branch in the EU that processes personal data, you're likely to be an EU establishment. It also applies if you are not an EU company. So if you're an Indian company, for example, a company based in India, only got offices in India, but you offer goods or services into the EU, whether you charge for those services or not, including, for example, newsletters, or you monitor behavior of of individuals in the EU. They don't have to be citizens. Please, it's a common sort of mistake that we see, is that people think, or companies think, that the GDPR applies to EU citizens. It doesn't apply. Citizenship agnostic. It's focused on the geography where those individuals whose personal data you're collecting are based. So it could be an Indian citizen in London, it could be an American citizen on holiday in France. A couple of terms which are worth bearing in mind in the regulation. Personal data. In short, there's the definition on the screen and in Article 4 of the regulation, but it's data from which you can identify either directly or indirectly an individual, a living individual, not a deceased person. and includes location data and a telephone number, for example. But you'd have to be able to use that data relatively simply to identify an individual. So an identification number 62134 means nothing unless you've got access to a directory or database which identifies 62134 as Alan Meneghetti, let's say. So the regulation only applies to personal data. It doesn't apply to confidential data, business data, anything like that, financial data, only personal data. The two main entities in the regulation, I suppose, that function within the scope of the regulation, are data controllers and data processors. Controllers are entities which control the manner in which personal data is processed and the means by which it's processed. So that usually is the entity collecting the personal data, or the entity on whose behalf personal data is collected. And processors are essentially the agents of the controller. They process personal data in accordance with the instructions of the controller. So for example, if you're a company A and you outsource your payroll processing company, the payroll processor is the processor, and they can only do with that personal data which is sent to them what company A tells them they can do, which is process it for the purposes of paying the employees. Yasmin, do you want to talk about the lawfulness of processing and consent?
Yes, so there are a number of grounds on which a company can process information. So you have consent, where the data subject gives their explicit, unambiguous consent. You have the performance of a contract, so where you feel that, or where in order to perform the contract properly, it is actually necessary to process the data. You have compliance with the legal obligation, and then another one, a good one to have, is legitimate interest. Legitimate interest is where the controller processes the personal data for it's quite a broad-ranging ground. So essentially, you can say our legitimate interest is to grow our business. This can be used where in all sorts of circumstances, apart from circumstances where such interest is overridden by the interest of the fundamental rights and freedoms of the data subject. In order to determine whether you have a legitimate interest, people or companies, we tend to do legitimate interest assessments. This basically means there's a three-part test: purpose, necessity, and balance. At Katten, we have prepared a template which we usually help our clients fill out, where we say, actually, purpose, what is your purpose for processing? Is it necessary to process this? And on the balance test, we say, actually, do the company's interest to process this data outweigh the interests or the legitimate interests of the data subject? This is not a test, sort of a black and white test. It is an opinion of the company where you assess yourself. The regulator can't always come in and say, yes, you are right, we agree, this is a legitimate interest. At the same time, they can turn around and say, actually, we think this might be, you're not processing on the basis of a legitimate interest. It is important to note, however, that it's not to be mistaken with an exception for a compelling legitimate interest, where personal data is being transferred to a third country. We'll talk more about that in detail later, but that's something quite important to bear in mind for now.
Okay, yeah, because there's a distinction to be drawn between the grounds of processing, the lawfulness of processing, which are set out in Articles 6 to 8, and then in the high 40s, I think 44 or 46 onwards, 44 onwards, in Chapter 5 of the regulation, the bases on which you can transfer personal data out of the EU to a third country. And one of those grounds of compelling legitimate interest. Consent as a ground is a tricky ground now. It used to be under the directive, the ground on which most companies, not all companies, relied, because it was quite a wishy-washy consent. Many of you listening will recall the discussions around opt-in and opt-out consents. Now the definition of consent has changed to that, which you can see hopefully in front of you, freely given, specific, informed, and unambiguous. So it's pretty onerous. And it also needs to be capable of being withdrawn at any time. What we've seen is a recent French regulatory, the French regulator, CNIL, enforcement actions against 2 companies where they essentially said they didn't have the requisite consent. And the time at which they got that consent was after they started collecting the personal data. So that really wasn't much good at all. So consent as a ground is tricky for 2 reasons. 3 reasons. 1 is the timing you get it. 2 is the boxes you need to tick. It needs to be freely given. So the argument is, in the employment context, it's not freely given, because if you want a job, you don't have a choice. It needs to be specific. You need to say specifically what that consents relate to. It needs to be informed. The individual needs to be told exactly what's going to happen with their data. It needs to be very clear, an unambiguous indication, usually by a specific act. The third reason why consent is tricky is that it can be withdrawn at any time. So if it is the sole basis on which you are relying from your employee, and your employee withdraws that consent, which they have a right to do under the legislation, under the regulation, then you've got a problem.
So that's interesting. So does that, it sounds almost like you can't take a ratificatory consent. Is that the sort of, is it very clear then the consent must always be taken prior to indulging in any kind of processing? And then if you did something inadvertently, you can't then tell the data subject that this is what has happened, and can you ratify, and then again give them the ability to withdraw and things like that?
I think the answer to that is I think you probably can, provided it doesn't happen all the time. I think what the regulators will do, as they did in TIMO and FITSUP, it was quite a broad, quite a wide-ranging, huge amounts of data subjects involved, and I think it was probably less of a mistake and more by design. I think if you make a mistake, you can on occasion, provided you're not doing it all the time, you can rectify and say, look, sorry, we made a mistake. But if it's a regular course of conduct, and these were sophisticated companies, it wasn't the first time they were in the market. But I think a ratificatory approach can be taken, particularly in these relatively early days. But I think, if you're trying to rely on that 2 years down the line when everybody knows about the regulation, it's going to be a slightly steeper hill to climb.
Well, I have a question. In a very specific context, and you can tell me this is too specific. A concern which seems to have come up very often for people has been the question of lead data management, that is customer lead data management, which is a sort of situation where in order to reach out to potential business leads, a particular person may obtain databases on a contractual basis from a database provider, customer database provider. What should the companies seeking this information, this lead data information, keep an eye out for in order to make sure that they're compliant with the GDPR and to make sure they don't carry-on liability from a database provider in that context?
Yeah, that's a really good question. I mean, this is an area which has been pretty grey historically. I think if you're the company purchasing the lead data, you've got to make sure, well, I suppose 2 things, speaking in the context of Indian companies based in India. One will be that you've got the necessary, that the company which is selling the data, the seller, has got the right to do so. Has got the right to sell that data, to transfer that data to you, and they are processing it lawfully in accordance with Article 6 to 8. And secondly, that they've got the right to transfer the data outside of the EU to a third country. So if you are buying it, for example, from a company in the EU, you'll probably, I mean, we'll get to this in a bit, but the bases on which you can transfer data outside of the EU are, it's to a jurisdiction with an adequate level of protection, which India is not. It's countries like Australia, Israel, Argentina, the Isles of Man, Jersey, Guernsey, Faroe Islands, or if it's to a company in the United States, that company has subscribed to the Privacy Shield, or if you're transferring it out of the EU but intra-group, you're doing it on the basis of binding corporate rules, or if you're not transferring it intra-group, which may be the situation that Rohan has asked about, you have the standard contract clauses attached as an addendum to your agreement to do so. So those are the things to watch out for, essentially, that there's lawful processing by the seller in the first place, that they've got the personal data legally, lawfully, and they're processing it lawfully, and that the individuals know that that such a sale could be made, and secondly, that the transfer is lawful.
Alan, I have a question. Could you explain what the Privacy Shield is?
Sure. So it replaces what used to be called safe harbor, which was set aside by a decision of the Court of Justice in November 2016, I think, about then, which was a way to facilitate the transfer of personal data from the EU to the United States, in accordance with EU legislation, because the United States is not a jurisdiction which provides an adequate level of protection. So the Privacy Shield it's a replacement concept monitored by the Commission and the US State Department, which companies subscribe to by making a public statement on their website that they subscribe to it and they afford all the protections to individuals. What it allows in practical terms is allows individuals who have got an issue with perhaps the way their data is processed in the United States, access to a free ombudsman service where they can complain and have their concerns looked into. Israeli, I mean, what it did is it arose originally out of the Edward Snowden allegations that the CIA and the NSA were snooping on personal data held in the United States, or by companies in the United States. And individuals had no really meaningful right of having that investigated, you know, European citizens. So if of course I could bring an action to investigate the actions of the NSA, but it would cost a fortune. Whereas now it's a free service. If you've got concerns about the way your data is being processed, that it's not in accordance with the regulation, that is being processed by a company in the United States, you can raise them. So it's essentially a statement by companies in the United States that accepting your data in accordance with the regulation. Just to mention that I said that the regulation has got to do with personal data. There are two types of personal data. There's regular personal data, which we've spoken about in the definition, and then there's what used to be called sensitive personal data, which is now called special categories of personal data. And this is the sensitive stuff, as you'd expect. And the definition's on the screen. It's your sexual affiliation, your sexual orientation, health data, medical data, political beliefs. And this is a distinctly European thing. You know, in the United States, for example, political beliefs are much more open. In Europe, they tend to be a bit more personal. But a lot of those are perhaps religious or philosophical beliefs. A lot of that is perhaps relevant for companies operating in the subcontinent here, particularly the medical data. So if you are in the business of processing a special category of personal data, then you can't process it unless you've got one of the following grounds are met. So the individual gives their specific consent, but of course remember that that can be withdrawn at any time. for medical reasons. So if, for example, I get knocked down in India and I can't consent, the hospital here can ask the hospital, my local NHS trust in London to send personal data, send my medical history to them, and that of course is permitted. If there's a health scare, for example, the Ebola virus that just seems to have broken out in wherever, somewhere in Africa, Congo, I think, that sort of stuff you can transfer it for those reasons. So perhaps that is relevant, and if it is, then one needs to be particularly careful, is the bottom line. This is the bit where a lot of companies, I think we're going to see a lot of issues, is the increase in the transparency requirements. We've always had this, of course, in privacy policies, but the regulation now details exactly what it is that needs to be set out in a privacy policy and told to data subjects. So who the data controller is, who the data protection officer is, we'll talk about that in a little bit, who receives the data, where it's transferred to, is it outside the EU, what is the basis for that transfer, how long is the data stored, that the individual has the right to withdraw their consent at any time, they've got the right to complain to a regulator, they've got the right to to make a subject access request, etc. And this is set out in Articles 12, 13, and 14. 14 is broadly the same as Articles 12 and 13. It just relates to the situations which occur where personal data is not obtained directly from the individuals. So Rowan's question about lead data would be relevant. So when the company purchases that personal data, the company that has purchased it, the purchaser, will need to inform the individuals which it hasn't obtained the personal data from about all these requirements. Yasmin, do you just want to mention this recent case, Aggregate IQ Data Services?
Yes, so on July the 6th of this year, there was a first UK enforcement notice under the GDPR. The notice required Aggregate IQ, so AIQ, to cease processing any personal data of UK or EU citizens obtained from UK political organizations or otherwise. Essentially, AIQ is a Canadian firm that uses data to target online ads at voters during political polls. The ICO set out that AIQ failed to comply with the GDPR, Articles 5, 1A to C in particular, and Article 6. AIQ was processing personal data in a way that the data subjects weren't actually aware how or for the purposes for which their personal data was being processed, and the way the data was being processed was not the way that was to be expected. Furthermore, the ICO found that the processing was also incompatible with the purposes for which the data was originally collected. AIQ had as well failed to comply with Article 14, so the transparency article, and had not provided the data subjects with the requisite information set out in Article 14.1 and 2. At this time, we don't know yet what the fine is, or if there will be a fine. The decision is being appealed by AIQ, so it's a matter of time to really see what's going to happen, but it is a good indication that the ICO is actually quite serious about these instances and that they will take action where they see fit.
And I think, so that demonstrates a couple of things. One is the importance of Article 14, where you get the data indirectly. But two, also the fact that the UK regulator is very focused on enforcing the regulation. And I think part of the reason for this is on the 29th of March, on Brexit Day, we are in the UK going to be a third country and outside the Eurozone for the purposes of, well, for all purposes in fact, but not least of which is the compliance with the regulation. And we will need to obtain an adequacy decision at some point, which could take a while. And so I think part of the rationale behind this is that the regulator wants to show that it's the standard that it is using is higher or more, it's applying a stricter standard than the other regulators in Europe. The only other regulator we are aware of that thus far has issued enforcement actions is the French one in relation to those two cases I mentioned earlier.
I have a question with Adi IQ, this issue, that's right. I'm just curious, I mean, on a practical level, I would presume that there may be a number of companies which maybe inadvertently or maybe because of not having updated their privacy policy, probably have a disconnect between the nature of the purposes for which they have stated that they are processing data and the actual purposes. Were there any extenuating factors which targeted AIQ specifically in this context? And I mean, because this is obviously something which has happened in maybe a couple of months after the enforcement date, and as given to understand the UK regulator was expressed some communication that compliance is an ongoing process. So it looks like something pretty like a message which seems to be sent.
Well, I think there are indeed, actually. I think one is Brexit, as I've mentioned. Two is they were processing political analysis data. So in the light of the Cambridge Analytica scandal, I suppose, which was a British company, they wanted to be seen to act. And I think both of those led to this, not least of which is it is the first time the ICO, the UK regulator, the Information Commissioner's Office, has issued an enforcement action against a non-EU company. So Aggregate IQ are Canadian. And so they went outside the jurisdiction, outside the Eurozone, under Article, and applied the territorial application of the GDPR under Article 3. And enforced. So I think it was a combination, the fact that it was used for a special category of personal data. Now, I don't know the data they were processing, but it was certainly used for a political means. But in the United States, with Cambridge Analytica, what they were doing is they were looking at the Facebook likes and the Instagram likes and the tweets and all the rest, that sort of social media stuff, and seeing what kind of car you bought, for example. And they were saying, well, if you bought a Ford, you were voting American, and so, which is why they said, Trump made these rather bizarre choices of where he was going to do his speeches in Pennsylvania, for example, because there was a feeling, which was quite correct by Cambridge Analytica, that they had analyzed this personal data and they could see that the demographic of voters in Pennsylvania were very pro-American, things they were buying, the things they were liking on Facebook. When I went to a talk by the chap who wrote the Cambridge Analytica software before it was bought by Cambridge Analytica, and he says it takes 50 likes on Facebook, whether you like it or whether you deliberately are trying to like something or not. So like 50 likes for them to get a decent indication of how you're going to vote. And of course, but we were talking many more likes. We were talking, people, they were looking at likes on Facebook upwards of 500. And so I think it was in that context, but a very good question, because it's quite bullish. The UK regulator has, by and large, restricted itself to dealing with naughty estate agents who are sending emails about buying a house in Battersea to people, and now suddenly they're going after Canadian companies who are doing political, analysis. I think it's very definitely a fact that they want to be seen to be enforcing a good regulator, a strong regulator, so that come 29th of March, we can say to the European Data Protection Supervisory Board in Europe and the European Commission, look, we really should be, have a finding of adequacy in relationships.
I think just an observation, but it sounds like an important learning for companies which are outside of the EU and trying to achieve compliance, that even early post the implementation date, companies which are outside the EU can still, be subject to an action by the ICO. And for what is essentially, from what I understand, from a purely legal perspective, a disconnect between the privacy policy and the purposes for which the actual data is being processed. That's interesting.
Well, I think that's right, and not two things. Oh, there we go. Back. Sorry. Plug me in. Sorry, I don't know if you can hear this. Sorry. I'll just keep talking. Two things. One is it's for regulators across the board, not least because there is something called a harmonization mechanism in the in European data protection legislation, which, sorry, we've just lost sound. Okay, there we go. Sorry, I think I'm not sure how much of that you missed. Not least of which is that what they're trying to do across the Eurozone is harmonize how actions under the GDPR are enforced. So what they don't want to have is a regulator in one jurisdiction being much more onerous than a regulator in another jurisdiction. So I think by the UK doing this, regulators in other jurisdictions are going to do similarly. Everybody wants to be seen to be enforcing it properly and strongly and robustly. So the UK has certainly set the benchmark for this. And so I think it's not just the UK regulator at all. It's going to be regulators across the Eurozone. And so I think you need to be particularly careful, even if you aren't in Europe, if you're processing, if you're caught by the GDPR, if you come within the scope, it will be enforced against you on the back of complaints. And what we've seen, the regulators, they've bolstered their staff by 60%. And we had a client recently who had a potential enforcement notice, which we dealt with pretty quickly, but I'd not seen that before. And I've been doing privacy for 18 years on the basis of a complaint of a junior lawyer up in Leeds, in the north of England, complaining that a company had been sending emails to him when he had already unsubscribed from receiving them, which he hadn't, but anyway. But we made sure he was unsubscribed, but the regulator was active robustly and swiftly. So I think you are, if you know, wherever you are, you have got to be very mindful of the fact that the regulators have now got some, they've now got some bolstered powers and feeling a lot more confident about enforcing things and a lot more aggressive. This is perhaps worth noting. The regulation sets out new details about the obligations on liabilities of processors. Historically, the privacy legislation, the previous directive focused solely on controllers. Now there's a lot more emphasis on what processors do. So particularly, I think companies in India which provide services, back office services, to companies based in Europe. A lot more obligation, and there's the opportunity for processors to be found liable for breaches of the regulation directly. In this regard, Article 28 is particularly important. This sets out the details here on the screen, which need to be contained in a contract between a controller and a processor, which needs to be written. And the failure to do this, the failure to have a written contract with the company asking you to process personal data, or indeed if you're a controller, perhaps you're a controller in India or a controller in the EU, and you are subcontracting for the processing of personal data with a processor, you need to make sure that you have these obligations set out in your contract with the processor. And the failure to do so is a fine of up, for this particular breach, if you don't have this written agreement between controllers and processors, a fine of up to 2% of your global turnover, or 10 million euros, whichever is the greater. And those obligations are pretty straightforward. They're there to ensure that processors, no matter where they are based, adhere to the main obligations in the GDPR around processing, around responding to breaches, around assistance with subject access requests, around security, the security of processing. see, I don't think there's much else to say on that one, other than it really is a mandatory requirement, both on controllers and processors, to ensure that you articulate this in writing. Yeah.
So while the GDPR says you're supposed to have a written contract in order to have a processor, a lot of people came up to me, often asking, they've had situations where their clients are perhaps also non-European, and they are the controllers, and they have not bothered to get into a written contract. So they were really, sort of panicking because they're being told that you need to have a contract, but the client is not showing any indication or, inclination to have a written contract. So we were looking at, then, them giving a notice, formally writing down saying that these are the security steps that I'm taking, and this I believe is required under GDPR, and this is, the processes I'm taking, and, to cover themselves. So do you think that would suffice, or what else should they get into?
Well, I think it's difficult. We've seen a lot of companies struggle with this because the processes just don't respond.
No, it was the other way.
The other way around, the processes.
The processors. So I met people in India, so other companies. So when I was discussing my contracts, they told me, what do you do if the client doesn't respond?
Oh, if the controller doesn't respond.
Yeah, controller wasn't responding.
Well, I think in that case it's almost slightly easier. Well, I'll talk about both situations, but to answer your question, I think exactly that. You put down what you do to comply.
Yeah.
You with your clients, you say, you tell them that you are in the process, or you are GDPR, currently GDPR compliant. You have these policies in place. This is your security policy, and if they want to see it, they can, to the extent that you can disclose that, you feel you want to disclose it, and to make sure that you are, and to notify them, and to send them that in writing, but to also record the fact that you've made numerous requests.
Yeah.
The other way around is trickier. If you're the controller and your processes aren't responding, we've seen that. So I'm my firm's data protection officer, and we've had a number of processes who process on a very small scale, who just haven't responded, perhaps. And I suppose there's a number of ways around it. You can either stop using them to process entirely, or you can say, look, you haven't responded. If you don't respond by the 5th of October, we're deeming you to have agreed. Not great. I don't like the deeming bit, but there's very little else you can do. And I think we heard earlier from one of Neela's clients.
That is enforceable?
I think it's more enforceable than doing nothing. I don't like deeming because there's, in a contract, and you've got to look at the change provisions.
Exactly.
But it's mandatory, and you've got a problem. I mean, you could complain to, you raise a request to the regulator and say, look, what do you suggest we do, and document that. I think with privacy, it's important to document. So as Yasmin was saying earlier, when you're processing based on legitimate interests, you document why you feel legitimate interests is a valid ground. And in this case as well, you say, look, we've made numerous requests to processor A, haven't responded. We've sent them this letter deeming the contract to incorporate this. Is there anything else we can do? Write to the regulator. I don't know that there's much more you can do. The reason for this, for Article 28, is because if there's a breach by a processor, there's two grounds on which to enforce that breach. One is by the regulatory avenue, by the regulator. The regulator can enforce for a breach of Article 28 for not complying with the provision, or for a breach of this, of a particular provision that they've undertaken to comply with. Sorry, not undertaken to comply with, but have to comply with under the regulation. But secondly, there's a contractual breach. And so, of course, the contractual counterparty, the controller, let's say, can enforce that contractually. So there are two limbs on which to get it. But I think as a processor, I think do exactly what you've said, but document. If It's vital.
Thank you.
Subject access requests is not, these are being used much more these days as people become more and more aware of them. These are pretty much the same as they've always been. This is the right for an individual, a data subject, to request that a company, a controller which holds personal data on him or her, detail what personal data they hold on him or her. There's some exceptions as to which personal data does not have to be disclosed. So, for example, if you're in litigation, not all data has to be disclosed. If you're looking at making redundancies, the personal data held around those redundancies, if they're current, doesn't have to be disclosed. The time period has changed. It used to be 40 days, now it's 1 month, but in certain circumstances it can be 3 months, and there's no longer a fee. There used to be a fee of €10 or £10 if the controller wanted to charge it, unless of course there's a lot of admin involved. You can charge a reasonable fee based on your administrative costs.
Sorry, just an observation, but there are some parallels here with the personal data protection bill, which has been recently tabled, and there's a similar situation with the bill where you have actually got, at least at this particular stage, a fee applicable for accessing your data, but there is no mention of a fee for data portability, which is interesting because in order to port your data, it's presumed that you would need an access. I was wondering if, you said that there's no fee, because there's a similar situation where, for example, for data portability under the GDPR, any kind of fee or request is required, or is it just?
I can give you the logic. Data portability is at a systemic level, and the requirement of the software would require your entire system to be, so configured in order to be able to port it. And you port it to common like Excel, CDS, and those kind of files. And if you try and levy a fee for it, then you are going to be charging for overhauling your entire system, which is not fair, right? An individual cannot bear that cost. But when the fee that they're referring to is, if someone is asking for too many copies and says, I want to have, this is a bunch of 100 pages and you have to bind it into a book. Sure. So it is the administrative cost and the fee that they're looking at recovering, but they're not looking at you being able to claim from, your customers and public the cost of you setting up your entire system to make it suitable to be able to comply with the law.
Right.
So that is the little difference between the portability and right of access.
Understood. I'm just looking at a situation where that would be considered to be a barrier to accessibility, even if, for example, someone a user makes a request for access in a purely digital format.
Yeah.
But,
What is the fee? Is the fee?
Well, as of right now, it's not specified.
Well, the problem we had in Europe was under the directive we said the controllers can charge a fee. And so some controllers did, some didn't, and you were never sure whether they were going to charge a fee or not. So what you ended up happening is every time someone stuck in a data subject access request under the directive or the local legislation, they sent £10 or €10 with it. Just so that, because that was the classic delaying tactic, is you'd go back and you'd say, we're not sure about who you are because you sent it from a Hotmail address which says, which doesn't sound like your name, Big Cat at hotmail.com, and your name is, Rohan George. Why is Rohan George Big Cat? And also, there's no fee. So what I would say to the Indian legislature, if they're going to charge a fee, they need to make it mandatory. That it applies in all cases, because what we had was just a situation of great uncertainty. And anyway, £10 didn't get you anywhere. I mean, it was stupid. The amount of work complying with a data subject access requests was infinitely more than €10 or £10. This one is the right to be forgotten under Article 17. Pretty much the same as it's always been. Although Google do note that there has been an incredible increase in the number of requests to it since the 25th of May for individuals to exercise their right to be forgotten, to have personal data removed. And in this regard, the UK leads the way, the most requests, followed by Germany and France. So individuals in those jurisdictions are very aware. I don't know what's happening to Britain at the moment. I mean, everybody seems to be acting very un-British. One, enforcing our rights, which is not particularly British, and two, departing from Europe. Some may say is very British. I'm not so sure about that. But this, the right to be forgotten is essentially what Article 17 does, is enshrine the decision in Google versus the Spanish regulator, which is a case which concerned a Spanish doctor who had been, some malpractice had been alleged but not proved 20 years previously or something like that. But when you Googled him, it came up that he'd had this allegation. Of course, he was getting a bit annoyed with it. It wasn't current, and he was losing clients 20 years later because they weren't coming to him. So the Court of Justice passed this decision, which is now enshrined in Article 17, where you've got a right to have personal data removed, which is no longer necessary for the purposes for which it was originally collected or processed. We've had a recent case a few months ago in the UK, perhaps not the best applicants you would want if you were acting for the applicants. There were two prisoners, murderers, who were still in jail, and they wanted it removed that they were still in jail for murdering people, and the court said, no, you're still in jail. So it's still relevant that people, that people can find it. But you can see a situation where, you've been released, perhaps for there was a case, someone had been released previously for a fraud, which had been spent a long time. The conviction was spent 10 years ago, and it was still coming up, and the court said, no, I think in that case it's fair that you remove this. So
it's removed from public data, but what happens if a company does a criminal background check following the GDPR process, of course?
Well, that's different. That's different, and criminal convictions are dealt with under a directive, which nobody really knows about, but it's sat alongside the GDPR, the Data Protection Directive, for purposes of processing criminal data. Yeah. So that you still...
Yeah, we follow that, yeah. So we are registered and do all of that.
You still need that.
Yeah, but you can still do that, right? So a person who's been convicted of fraud.
Well, that's if it's relevant, sure. Yeah. If it's, I mean, if it's 20 years previously and they've had a clean record since then.
Yeah, but the bank may not want to hire someone who's convicted of.
Precisely.
Yeah.
Precisely. But they've got a right to object, because that would probably fall under the profiling. Oops, conviction, fraud, profiled, automatic no. So you've got the right under profiling. We'll get to.
Yeah. Automatic profiling.
Automatic profiling, to have a human intervention, to have that decision challenged anyway. But note at the bottom, it's in red on my screen, it looks like it might be in black on yours, that you can resist the right, you can resist the request to have an individual's data forgotten. So if there are overriding legitimate grounds for the processing, so Vasantika's question about fraud, or reasons of public interest, or for the establishment, exercise, or defense of legal claims, if you're dealing with perhaps a fraud in the company, and you can say, well, 20 years ago he was also convicted of fraud, so it shows that there's not an unfamiliarity.
Would the freedom of speech or right to information be, so those would be legitimate. What would they fall in legitimate grounds or public interest? Or?
Well, that is a big question to answer, only because there's been a lot of Court of Human Rights, well, not a lot, but there's been a fair bit of Court of Human Rights, European Court of Human Rights decisions on this, which really tend to revolve around a rather riveting area of tax concerns. And for some reason, in the Nordic countries, how much tax you pay is incredibly exciting to people. And journalists obtain one of the benchmark case for this was a publication in the newspaper of everybody's, of people, certain individuals' tax records, or how much tax they paid. And this was objected to by the individuals. They said, well, there's no reason, this is a complete breach of our right to privacy. And the Court of Human Rights said, well, actually, it's counterbalanced by public interest and the freedom of speech of the journalists. And so the journalists prevailed. I'm not sure how many people read tax records, but I can see that there may be some interest. If it's dark at 2 o'clock in the afternoon, what else are you going to do? But yes, there's a balancing with all of these things. And the GDPR, a lot of it is based on the right to privacy under the Convention of Human Rights. And with all human rights, as you'll know, there's balancing. The exercise of one is counterbalanced against the other. So the right to privacy is balanced against the right to free speech and to public, reasons of public interest. So the fact that there's a sex offender, which is particularly prevalent in Europe for some time, there's a sex offenders register, and there's often information which is publicly available that sex offenders are living here, and here, which is difficult because it impacts on the right to privacy. Someone's conviction's been spent. Is it still public interest? How old is that conviction? The safety of the individual, because often they're targeted. So there's to answer your question, yes, but it's a difficult area. Google tends to take the view that it will delete the data on the request of an individual because it tends to be related to ex-partners or ex-husbands or ex-wives, rather than individuals saying about my conviction. But if there is a conviction, then they will look at it and see how relevant it is and either accept or reject it. But it's I think to the end of July, something in the order of 70,000, 71,000 requests from the UK from May. So a lot. It's keeping someone very busy.
Thank you, John.
Rather thankless. Quite boring as well, actually. So profiling, well, we've spoken about this very briefly. You've got the right not to be subject to solely automated decisions, but it can be, if you for example, apply for a mortgage or a loan, the bank can say, look, we do process this data. You consent to it if you want that. Consent is a difficult one to really hang your hat on here, simply because, as Yasmin said earlier, it has to be freely given, specific info. Freely given is the problem here. If you want a loan, you don't have much choice. I think a bank would say, or a financial institution would say, it's necessary for entering into a performance of a contract. That's how we draft. We've got a number of financial services clients, and we say, look, it's necessary for the processing of entering into a contract. But if you don't agree with the decision, you are allowed to appeal it. It can be human intervention. You can show certain extenuating circumstances, etc., as to why.
Because the profiling for a bank, for the purpose of loan, would cover both categories, like both special information and profiling.
Potentially, but it could if you had I don't know, let's say an overdraft in your credit card of $20,000, and the bank saw that as an issue, and they refused the thing, refused the loan. You could always object and say, well, hang on a second, I can clear that loan, or I'm clearing the loan, or something like that. So you've got the right to object to that solely automated decision making. So at the bottom, you see the rights of the data controller the right of the data subject to contest the decision. Sorry, Rohan?
Sorry, just one more point. I guess the word solely automated does provide a certain amount of leeway as far as the actual decision-making process, as far as something like a loan is concerned. There would be some kind of human intervention at some point in the process, which would remove this from the purview of solely automated. Would that be sufficient?
Yes, it would if there was. Often these, well, certainly in Europe, with credit card providers like MBNA, it says get an answer within 3 minutes. So that presumably is solely automated. But yes, indeed, if it was partly automated, then it would take it out of the purview. moving on to, excuse me, the security of processing under Article 32. Well, this applies to both controllers and processors. Actually, let Yasmin talk a little bit about this, so I can have a drink of water.
Well done. So with respect to the security of processing, there are a number of, under the GDPR, there are a number of sort of security measures set out. So for example, pseudonymization and encryption of personal data, so that actually whenever you see the data, you can't make out who that person is. So for example, Alan Meneghetti, and his name gets scrambled so that you have all the letters together, but you can't make out who the name is. That's sort of pseudonymization. There's encryption measures as well. The important thing under the GDPR is essentially, and Article 32 sets out sort of steps or security measures which the GDPR deems would be appropriate, depending on obviously the level of risk, is to make sure that your company, depending on what it does, has ensured that it can adequately protect any personal data that it actually processes. A good example is the Equifax fine, which it is important to note that this actually was fined by the ICO under the old Data Protection Act, so the 1998 Act, not the GDPR. The reason for this is that the breach occurred in 2017. It's still a good indication as to the extent the ICO will go to. They fined Equifax £500,000, which is, I think, the highest fine they can fine, for failing to protect the personal information of up to 15 million UK citizens during a cyber attack. It is interesting to note that actually the information systems were based in the US, but it was found by the ICO that actually the UK entity was responsible for making sure their US parent had adequately protected the personal data of those UK citizens. Generally, this is something we see in contracts as well, that there are a lot of different ways to protect your data. So it is very much company, I suppose as well, type of business you do. So it is very much unique to your company, and it's something that you need to make sure as well that your company is actually able to do this. If you set out in a contract that I will do X, Y, Z, it is important that you actually also perform those obligations.
Thank you. And I think that the important thing, or a pertinent thing to take into account here is what is required under the GDPR. It gives you measures, it sets out the measures which Yasmin mentioned, the pseudonymization and encryption. But what it does do is it gives you flexibility in determining what those are. If you look at the bit at the top of that slide, it talks about the cost of implementation, the state of the art. So where where the state of the industry is, what kind of personal data you're processing, what kind of industry you're in. What it's trying to say here is, look, what's secure today will not be necessarily the state of the art, will not be the industry standard in 6 months. So you'll need to constantly update. So just because you're GDPR compliant today doesn't mean you'll be GDPR compliant next year. And each industry is different. So you need to look at the market standard for your industry, taking into account the kind of data. And so it needs to be a qualitative assessment by your IT team.
So one question on this, Alan. Under at least the existing data protection regime in India, there's a presumption that compliance with the ISO SEC 27001 standard, which is actually that's enshrined in the sensitive personal data protection rules in India, is a presumption that is compliance to some extent or the other, reasonable compliance with the standards essentially. Are there any standards which are being acknowledged as any technical standards which are being acknowledged as broadly compliant with the level of security appropriate to the risk at this particular stage? Is there something which which is emerging at least as an industry standard?
Not that I'm aware of. 27,001 is the standard on that, and I think if you are 27,001 compliant and you act, well, the way the standard works is you do have to be compliant. I mean, you can demonstrate that. I think that'll go, a hell of a long way towards compliance. The other thing which the regulation makes provision for is compliance with codes of conduct, which can be published. Now, I don't believe any codes of conduct have been published yet. I've been approached by a couple of clients to discuss these codes of conduct, and quite a big job. In the sense, not so much, well, from a work point of view, I suppose, drafting and getting everybody to comply, but also just getting everybody to agree on what that code should be, because they tend to be for member organizations. So, it would be, for example, the Bangalore Chamber of Commerce, its members signed up to a code of conduct. And those go a long way towards demonstrating compliance. And indeed, the regulation says it is a way to demonstrate compliance, because with a code of conduct, you draft it, you agree it, and then you have a regulator approve it. So it's a standard, as you were saying, Rohan. But I am not aware of any that have been approved. There may be some in the pipeline, but of course nobody would know because they're private until they're published. And what happens is once they're published, so perhaps what will happen is these one or two will be published, and then people will say, well, that's been approved, so we'll base our code of conduct on that. But that is another way. But it's an analogy to 27,001, which is, it's independently policed. There's someone who checks compliance with the code of conduct, which is something certainly to think about, particularly for organizations like this.
Since we're talking about codes of conduct, just correct me if I'm wrong, but I was wondering at some point the regulator is required to release a model code of conduct at some point or the other?
I don't think so, simply because these are industry specific.
Or meant to be?
They're meant to be industry or not even industry specific, membership organization specific. So what may work for the Chamber of Commerce may not work for an airline alliance, may not work for some sort of trade organization. But I think, what the regulation is doing is it's encouraging things like binding corporate rules. It's really pushing that, and it's pushing codes of conduct, which are, I suppose, short-term hard work to get, but for a long-term ease of life. Because what you do is you have a body such as Chamber of Commerce, just to use that because it's relevant here, which has a code of conduct drafted. In order to be a member, or a platinum member, perhaps you subscribe to that code of conduct. Part of that is all your suppliers, for example, have to subscribe to that code of conduct. And then you get a third-party entity to monitor that code of conduct and to certify compliance. So you could get an EU lawyer to once a year do an audit, which you could do relatively inexpensively, and it would tick a lot of boxes. And so short-term, initially hard work to get it done, some effort, but in the long term, particularly for companies that don't process solely EU data, or where only EU data is not a huge portion of what they process, it has to be a lot easier for them to be compliant and to demonstrate compliance should there be a query. Moving on to breach notification. I'm conscious that we haven't got a huge amount of time left. This, of course, is new under the GDPR. Across the Eurozone, there were differences in the member states as to when you had a breach, whether you had to notify that breach or not. Now, if there's a data breach, you have to notify the regulator, you as the controller, and processors have to notify controllers, and the controllers have to notify individuals if it's going to impact, if there's a high risk to the rights and freedoms of individuals. So you have to, in summary, you have to notify the regulator, the relevant regulator. You may have to notify individuals. What the ICO has said in the 5 months since we've had the GDPR in place, 5 months or so, two things about the notification of breaches. One is there's been an over-reporting. So companies are notifying when they didn't have to notify. So people are scared. Because they notify everything, so the ICO is getting fed up. And the other thing is the ones that are reporting, which need to report, they're not giving enough information. So with those ones, the ICO is pulling its hair out. So it's a tough time in Manchester for them because they're getting every little slip. If a guy left his, in the UK, typically what happens on a Saturday morning is 500,000 people wake up and think, oh, I've left my work laptop in the pub because I had too many beers. And then they go along to the pub and the pub says, here you go, here's your laptop, and that sort of thing will be reported where there's no data breach, or there's only a potential data breach. And then there'll be, where there is a data breach, the companies won't know anything about the data breach. They'll know so little, they'll just say there's a data breach because we lost a USB, and they won't know the information on that USB, etc. So the ICO is sort of a bit stuck here. They've created a bit of a rod for their own back. But the best thing to do, really, in short, is two things. Is to have a breach response policy now. If you are caught by the GDPR, get a process in place now so that you're proactively dealing with breaches. You're not reacting to a breach, on the fly. And the second thing to do is call your lawyer as soon as there's a potential breach. Call Rohan or Neela, or whoever lawyers, and says, I think we've got a breach. That's important. It needs to be documented. As soon as there's a breach, you need to start the documentation process. This, of course, is the fines I think everybody knows about, up to 20 million or 4% of your global turnover total. So that's gross, not net. So it's a lot of money if you get it wrong. Talk very, very briefly about impact assessments. Yasmin mentioned it earlier in the context of legitimate interests. This is more generally if you're using a new technology, something modern, something that's innovative, which potentially, if it could present a high risk to the rights and freedoms of individuals, you need to do an impact assessment, which is really just an assessment of what the technology is, what the issues are with it, where the risks are, and how you're addressing those risks, and document that. And it's in a sense, it's a process to ensure that you've dotted the I's and crossed the T's. And with my lawyer's head on, it's a way of ensuring that if something does go wrong and a regulator does come in, you can show them, actually, we have thought about this, and this is how we addressed it. Data protection officers, if you are processing a large amount or controlling a large amount of GDPR relevant data, you need to appoint a DPO, a data protection officer. And they don't have to be located in Europe. They can be located, as Vasantika is, in Bangalore for her company. But you will, if you have got, if you haven't got, either way actually, you need somebody in the EU. So if you haven't got offices in the EU, you need an EU representative. And if you have got an office in the EU, but your data protection officer is located here, as in the case of Vasantika's company, she's got someone in London who's the representative. And that's just so that the regulator can deal with someone in the same time zone, really, and someone on the ground. And also, there's a liability aspect. So if you're just based in India, you've got to have a representative in Europe. If and a fine is levied against the entity in India, and they just ignore it, the entity in Europe can be fined. The individual acting as the representative. So
just out of curiosity, if this representative is an employee,
can be a third party.
All right, but if they are an employee, can they take on liability for the entity which they acquired?
You'd say it's so and so at our offices in London. So I think you'd indemnify them. Yeah.
Also, but the regulator can nevertheless place liability on the employee directly.
And the representative, yeah. Good.
Liability would be against the company. Right?
It would be against the company, though, yeah. But if the company says forget it, it's slightly different if there's an entity. There's a little bit of a lack of clarity. But if I take on a role as Concentrix's representative, Katten, we could be fined. Alan at Katten, for you, the fine could be levied against you, but could be enforced against us.
Yeah, but we have offices all over.
Correct. It's different. So that is. But yes, essentially the fine can be.
So that is for those who do not have an office in there. Or are you saying any external DPO could get fined?
Well, you need a representative in Europe. So you need either an office or an entity you've nominated as your representative. So there are GDPR representatives, companies acting as such.
But just hypothetically, taking this to the point of absurdity, assuming a company appoints a representative in the European Union who's an employee and who's paid a salary of about 35,000 euros.
No, it wouldn't really work.
Yeah, that's what I'm curious about. I mean, if they were going to fine the company a few million, what impact would that have on this employee whose exposure to liability is about 35,000 euros? It's just
I'm just desperately trying to find the relevant the language in the regulation which talks about the representative, which says the designated representative should be subject to enforcement proceedings in the event of non-compliance by the controller or processor. It's rather nastily hidden away in recital 80. So that's all we know on that. The main text of the regulation doesn't say that. But as I said, at the end of Article 80, stuck right at the end, they should be subject to enforcement proceedings in the event of non-compliance.
this is the recital.
Yeah, the recital.
So this is a good meta question. I think you maybe dealt with this to some extent the last time you spoke. What is the level of enforceability of the recitals to achieve that, given that they occupy half the space in the text?
Well, it's difficult. I think that well, let's take this particular one. It says the designated representative should be, so it's peremptory language. I think it's a clear indication on the part of the legislators that the individuals, the representatives should be subject. I think it would be difficult to see how a regulator wouldn't go against the representative if it couldn't enforce against, let's say, Samvad Partners, and you were ignoring their fines, the fine, and you were ignoring their notices. The regulator would, of course, be more than delighted to go against me as your GDPR representative and get me to deal with it. So presumably I would have some form of contractual undertaking with you. But to answer your meta question, I think they're persuasive.
Yeah.
That's generally just to be the rule. Under English law, it may be different in other jurisdictions across the Eurozone, but recitals tend to be persuasive. It's difficult to see how, depending on the language used, there's a whole body of jurisprudence about that, which I can't, I don't know is the short answer, other than to say they're persuasive is the general rule, but not binding. Well, I won't bore everybody with the tasks of the DPO, because what I do want to talk about in the very few minutes we've got left is data transfers to third countries, which are quite important. They're set out in Articles 44 to 50. Now, as Yasmin noted earlier, it's important to distinguish between Articles 5 and 6, the lawfulness of processing, so the basis on which you process personal data, and how you get personal data out of the Eurozone. And there are only 4 bases. One is you transfer it to a jurisdiction which has an adequate level of protection. 2, you transfer it under a mechanism, it's like the Privacy Shield, or a mutual legal assistance treaty, or some form of international agreement. I've looked at those recently, and if possible, don't even go there unless you're truly bored. And it's a long road to get anything under a mutual, under an MLAT. Thirdly, binding corporate rules. So that operates intra-group, and those are basically the internal company rules as to how you transfer personal data between entities within the company. So Microsoft has binding corporate rules. And these are approved by a regulator. So you draft them, they're approved by a regulator, the lead regulator, whichever the jurisdiction is where you have where you identify with your lead supervisory authority, and then you transfer on the basis of that. We've done some of those recently. It used to be quite a long process, so nobody did it. The process has been sped up considerably. And lastly, model contract clauses, which are just the standard clauses, which can't be amended. There's a couple of options that you have to elect, for example, the governing law, but other than that, do not amend them. They still, rather unfortunately, still refer to the directive 95/46 and not the regulation. They haven't been updated, which just gives you an indication of how tied up Europe is with, I suspect, Brexit. They haven't even updated them, but don't amend them to refer to the regulation. Just don't touch them at all, because as soon as you adjust them, they become invalid. So those are really the four bases or so on which you can get personal data out of Europe. There are a couple of other emergency bases. One is consent. Difficult again to, as I said earlier, to rely on it because of the scope of it and the fact that it can be withdrawn at any point. And a legitimate interest which is compelling. But the ICO has issued recent guidance on this in August, and says if you use a compelling legitimate interest, then it needs to be for circumstances which are not repetitive, so one-offs, not affect a lot of data subjects, so a small number, and you need to notify the individuals that you're doing it, and you need to notify the ICO in the UK. And if you're presumably, to be safe, other regulators, although no other regulator, as far as I know, has made a decision, has issued guidance on this. But you need to notify the relevant regulator that actually you're transferring it out because to protect the data, or because you need to do something with the data which you can't do in the UK or Europe because your servers are down or something. And that's really it. There's, hopefully you will be distributed the slides. I'm sure Neela will circulate them to the relevant people. A little infographic at the end, very high level as to the 10 steps to GDPR compliance, which you need to, some of which you need to do, and the other that your external legal counsel need to do. And I think that leaves a couple of minutes for if anyone's got any questions.
Yeah, we've actually got like half an hour questions.
Oh, more? Oh gosh,
But
did I rush?
That depends on, schedule to the work.
Oh, okay.
I think we can take questions if there are questions on the chat. So, Rohan, you want to lead on that?
On the questions?
Yeah, in the sense, you can just,
Yeah, sure.
just to give Alan a break.
Yes, thank you.
I mean, obviously, it's something that Alan
Q&A.
or Yasmin can answer.
Thank you.
As of right now, we're waiting on questions. This is the questions, no? So currently we have we're awaiting questions.
Oh.
So if anyone is interested in addressing any questions to Alan or to the panelists in general, then please go ahead and ask your questions. We'll wait. In the meantime, we'll address questions from people who are within the room for now, and wait for the open questions. So I did have one particular query, at least, which addressed. Sorry, Alan, to put you back on the hot seat so quickly.
More rest for the viewers.
I might start asking Roland questions.
Yeah, good for me. No. So, with this definition of a person under the GDPR, personal data, another question which keeps coming up is that when this again comes up in the context of big data again, but when you contact somebody who is occupying a particular position within a particular organization, you're reaching out to somebody, but you are also reaching out to them in their capacity as a person within an organization. Now, how does this square? Is this considered to be a violation of their personal data, or is it a violation? I mean, is it not something which is within the scope of GDPR? I'm not sure my hypothetical is too abstract.
No, I think it depends on how you do it. If it's a bespoke email, it's just a bespoke email. I think that's just a business-to-business sort of email. If it's a mail shot, you'd probably do it on the basis of your legitimate interests. And when Yasmin spoke earlier about the balancing with the right to privacy or the right to privacy, how you balance that. What we make sure our clients do is when we're doing a legitimate interest assessment, saying, look, we can cold email you. We don't regard that as a violation of your right to privacy, because we'll put an unsubscribe button at the bottom. So if you don't want to receive these emails, you just click unsubscribe.
Okay.
So I think as long as there's an option for the individual to say get lost, or no, I don't want to hear from you again, if you're doing a mass emailing, I think that's a relatively straightforward way of addressing any impact on the right to privacy. That's my personal view. It's not based on guidance, because there's not been any guidance. There's been broad guidance on legitimate interest, but I think when you're doing your legitimate interest impact assessment, one of the things you need to do, as Yasmin mentioned earlier, is how you balance your right to legitimate interests against the individual's right to privacy, one of their fundamental rights and freedoms under the European constitutional documents. And for me, the simplest way is, well, it's just easier. They click a button and say no more, and they exercise their right to privacy. Right to privacy is not an absolute right. There's no, it's a relative right, what they call a relative right. It's relative to other rights. It doesn't operate absolutely. And I think that the easiest way, it's not a big deal. It's not a hassle to click on and unsubscribe.
We have a question from Paresh. Paresh has asked if we are a processor based in India offering a software as a service solution to an EU entity, brackets controller. Our servers are based in multiple locations. Do we need to have the server of EU citizens only in the EU? Right.
Well, that's a good, it's an excellent question. Firstly, Paresh, it depends whether you can segment your data, your personal data, because a problem that a lot of companies have is segmenting which data is coming from where, or what data is GDPR relevant and what data is not. If you can, you don't have to have a server based in the EU, but it's probably a lot easier if you have a server based in the EU, simply because you don't have to deal with a transfer out of the EU. You'll still need to be GDPR compliant, and you'll still need the controller to say, because the controller will be the entity, presumably with a privacy policy, informing the individuals what's happening to their data. Our personal data, the controller is saying our personal data is transferred to third parties for the purposes of whatever your SaaS solution provides. But, and this depends where you're based. If you say your server is only in the EU, the controller will say, but we don't transfer your personal data, Mr. Data Subject, outside of the EU. If your server, Paresh, is located out of the EU, the controller will have to say, but we transfer out of the EU, but with the entity with which we contract with, Paresh, we've agreed standard contract clauses with. We transfer it on the basis of standard contract clauses, and we ensure that they are GDPR compliant. So it really depends what the controller says. it depends on how, for you, I suspect it will make your offering a little bit sexier to EU entities if you say we don't transfer it outside. We are GDPR compliant. Oh, and by the way, there's no transfer out of the EU, because it just makes the controller's life a little bit easier. But as I say, if the server is outside the EU, they'll need those last slides that I went through with you. There'll need to be a basis on which they transfer it outside the EU, which presumably the easiest one is standard contract clauses.
Great. So we have a few more questions now. The next question is from Sridhar Ranganathan. Is consent a duty of data controller, or can the data processor obtain on behalf of the controller? If so, what are the safeguards the processor has to take or adopt? Is it an option for the data processor or the controller to adopt either of the SCC or the privacy shield? So, yeah.
Okay. It's not a duty. Well, if you're relying on consent as the basis on which you're processing personal data, and so bear in mind my comments around that, it needs to be obtained. Now, the primary obligation, of course, is on the controller, because that's the entity with which you as the data subject assume you're giving your information to. So if, for example, I'm flying on Emirates Airlines to Bangalore, I'm assuming when I give my personal data, I give it, my meal choice, let's say, I want a veg meal, which would be personal data, sensitive personal data, potentially, to indicate perhaps I'm Hindi, or I would assume I'm giving it to Emirates. Emirates may have outsourced that to their catering, to a catering business, which is not part of the Emirates business, but I won't know that. But as part of that outsourcing, they would say to the processor, the catering arm, you can collect this data just for the purposes of providing this service, and you get the consent. So it depends on the contractual relationship between controller and processor as to what the processor's job is, what their job is. What are the safeguards the processor has to adopt? Well, I suppose contractually with the controller, they need some form of indemnity if they get it wrong, but I suspect the controller would probably want that from the processor. It depends on the bargaining position. Oh, here we go. Are we off?
Oh, good. All the old questions get bumped up.
Are we mute or not? And
Hi everyone. I think we had a small problem with the webinar, but I think we're back online. I hope everyone can hear us. Yeah, we are going to address a question from Akansha. Which, by the way, sorry, there's been a slight issue where the questions earlier asked seem to have been lost. So if you don't mind just putting down your questions again, I know it's a bit of a problem, but that will be appreciated, and then we can have the questions in front of us. We have the last question asked by Akansha relating to privacy policies across different verticals. So Alan can go ahead and answer that. And in the meantime, if you could put down your questions, that would be good.
there was one coming in there.
That is not a question. That was just a snarky comment.
So the answer is you can have different privacy policies. what we tend to do is draft a single privacy policy simply because it's easier to manage for the business with separate sections in it, saying if you are submitting your personal data from Europe, then this applies in addition to the rest of the policy. If you're not in Europe, then the rest applies just as it is. Can a subsidiary located in the EU, which can act as an EU? Yes, is the answer to that. As long as it's an entity in the EU, it has to be in the EU. They need someone. The regulators need someone to go against in the EU or to deal with in the EU in the case of an incident. Wow. Can you speak into the mic? Yes. Okay. Sorry. Sorry. Where's the mic? Here.
Yes.
Sorry. Apologies.
Here. This is the next
I normally get told I'm talking too loudly, so I'm terribly sorry. Okay. Would the GDPR, apply to a non-EU company which monitors the behavior of EU data subjects through a third-party research agency, or through the review of third-party research papers, reports? Well, it has to be personal data. So I would think that third-party research papers or reports may not deal with personal data. Through a third-party research, well, the third-party research agency would need to ensure that it had the right to do that monitoring. And you would need to, yes, I suppose you would. It would probably apply. You'd have to look at the individual circumstances. You'd certainly have to make sure that you had the right safeguards in place with your third-party research agency. It's quite difficult to look. No, there's no bright line test. Is the question? Is there a bright line test? Quite difficult to answer that in directly. It's certainly the research agency it would apply to, as we saw in the aggregate IQ and the Cambridge Analytica case. How detailed should the consent clauses be? Does it differ depending on how much data is being collected? The consent clauses, they tend to relate to the privacy policy, really. So the privacy policy details the specifics of the data being collected. So that ticks the specificity box. There needs to be an unambiguous indication of consent, and that is stated to be an affirmative action, so a signing of a paper or the ticking of a box. It doesn't differ upon how much data is being collected. It's more of a qualitative test than a quantitative test. So the type of personal data that's being collected is the litmus test, not how much. Would deletion of illegally collected data serve as a defense? Yes, I think it would. I don't know if it'd be an absolute defense, but you'd certainly have to. It'd certainly be a start, and you'd have to look at the relevant circumstances as to why that was unlawfully collected. So I'm just picking up on the word illegally. It's not a criminal piece of legislation, so there's no legality around it. It's more the lawfulness of it. So there's no criminal sanctions for a breach of the GDPR, but there are fines that can be levied. Fine, do you want to do the next question?
No, sorry, I just want to read it out. This is from Ajay Krishnan. Is there any GDPR certified entity to certify GDPR implementation?
No, is the short answer to that. That goes to Rowan's earlier question about the ISO standards. But no, and when we've spoken to the regulators and asked them whether there are any, one of the qualifications for a DPO is that they need to be an expert, in inverted commas, on European privacy legislation. We said to the regulator, so are there any courses that you recommend? And they said, no, of course not. It's up to you. You've got to prove it, that the individual is an expert, whatever an expert means. You know, I mean, clearly it would be someone like me who spends their life doing this stuff, but is it someone whose day job is not doing something quite as tedious as mine? are they an expert? What does an expert mean? We've taken my view on that is someone who's qualified has passed some qualification test, as Vasantika has done, for example, with her company. Some IAPP certification, for example, would probably be a good box to have ticked. But the regulators say no, there's no certified entity. Should I ask a question? Oh, sorry, I didn't say that. Sorry.
No,
Sorry, this is my fault entirely. Oh, right, I'm not going to move the camera. Sorry.
Come back. Don't worry about it.
All right.
So the next question is
Sridhar.
from Sridhar. Is consent a duty of a data controller, or can a data processor obtain on behalf of the controller? Oh no, so I think this question has been answered already.
Okay.
Yes, we can move down from this one. Sridhar's question is also.
Is it an option of the data processor or controller to adopt
Either SEC or a privacy shield?
Yes, I suppose it is really. Yes, you can indeed. You don't have to subscribe if you're a company based in America to which personal data is transferred. You either one of the bases that you transfer personal data outside of the EU is Privacy Shield, but of course that only applies to entities in the States. Or the standard contract clauses. But if you're in the States, you've got the option of 2. If you're in other jurisdictions which are not regarded as adequate, so for example, South Africa, you'd only have the option of an SEC, of the SCCs. So yes, if you're in the States, you've got an option, SEC or the Privacy Shield.
Go ahead, Adam. You can just read it out if you wish.
Okay.
Save the camera presentation.
me constantly breaking the connection.
Right.
What happens when a customer/EU resident posts his data on an Indian website for processing, voluntarily no processing in the EU? I think that would be consent. I think you need to make sure you had the consent, so you would need one to have a robust privacy policy which detailed the specifics of consent, so that detailed exactly what you were going to do with that personal data, so that you ticked the box of specificity. Freely given, obviously, is done. He's uploading it himself. He doesn't have to upload it. It's informed. Again, the privacy policy details what, so he knows what his consent's about. An unambiguous indication. I think certainly a tick box to consent, an I agree box. If you notice, for example, Apple, they'd have a double tick box, which I think is very good. You agree, and then do you really, are you sure you agree? I think that's very good. By this point, you're hammering your iPhone, agreeing. And the fact that they're uploading all indicates. The important thing to remember with that is to keep the consent, because there's no point getting it and then not keeping records of it, because what we had that case I mentioned earlier with the chap unsubscribed. He said, I don't know what the hell this is, that I'm getting all these emails. And we said, well, hang on a second, we'll unsubscribe you, that's no problem, we said to the regulator. But here, by the way, is the record of his consent to receiving these emails. So they sent the ICO had sent us quite an aggressive email, which we felt was a bit unjustified in the circumstances. And so it's important to keep records of consent. So to answer that question, yes, but you need to make sure that you've got a detailed privacy policy so that the individual uploading it knows exactly what's happening and where the data is going, because she may think it's in Europe. I'm sorry, it's not saying now who the questions are from, so I can't read the name out, which is probably just as well because my pronunciation would be awful. But the next question is whether the data of Indian entities can be collected from foreign servers without breaching any of the privacy and data protection laws of the respective country. I don't think that would be, if it was an Indian entity, it wouldn't be personal data, but if it was an Indian individual in India, then it wouldn't come under the GDPR. If it was an Indian individual in Europe, then it would. But I don't think that would come under the GDPR. Could you just perhaps redo that question if I've misunderstood that? The next question is what is undue delay, and can a processor have a policy that the breach will be notified within 48 hours to the controller, I suppose. Yes, of course you can. You can have a policy. What's undue delay? I think, well, the legislation says within 72 hours, but of course, what we must be mindful of is you don't need to have full details of the breach by the time you notify it. It says within 72 hours of becoming aware of the breach. I can just read the language quickly. To notify shall without undue delay, so as soon as you can, and where feasible, again, where it's possible, not later than 72 hours after having become aware of it, notify the personal data breach. You don't have to detail every aspect of the breach. It's not what 33.1 is saying. You've just got to notify the regulator of the breach. However, it's a personal data breach. You may not be aware, you may have become aware of the breach, that there was a breach of data, a data breach, but you don't know whether any personal data has been breached. It's a difficult situation perhaps to understand because 72 hours is quite a long period of time. But for example, if you lose a USB stick, you may not know what's on that USB stick, and it may take you a while to work out what's on that USB stick, or what's on that laptop, or what's been hacked. Because if it's just a breach of confidential information, then of course, which is not personal data, there's no obligation to notify. Is there an exemption to the appointment of a DPO based on the number of employees employed by the data processor? No, it's got nothing to do with the number of employees. It's got to do with the volume of data. So you could have one employee and process huge reams of data, personal data, and that would.
There is a threshold of 250 employees in some countries that they are applying.
They are applying. That goes back to the penultimate draft of the regulation, where they try to articulate a number.
Mm-hmm.
Not for the UK, but
okay, not for UK, but GDPR. So, for example, Romania and Hungary and some of them seem to be still.
So do they say if you
have more than 250 employees in the country, you need to have a DPO.
Okay.
Because then assuming your business does not require huge volumes of personal data to be processed, but because you have this many employees, you are processing your employee data, and that itself requires you to have a DPO is what they've been taking a stand.
Yeah, well, that is the derogation that each country can have. I wasn't aware of that. So thank you, Antika.
Thank you.
How do we understand what is large-scale data, as it is very subjective? Yes, indeed. How does the EU Commissioner differentiate that? Again, if you don't think that you need to appoint a DPO, do an impact assessment. Do what they call a privacy impact assessment, a PIA, and say, we don't think we need to appoint a DPO because, and then you set it out, just like a math solution. But what I would say to you is, yes, you're 100% right. It is subjective. It is meant to be subjective. It's like the security of processing under Article 32. You need to justify your decision, and you need to document that, so that if there is a query, then you can say, well, look, okay, maybe we got it wrong, but this is why we proceeded on the basis, on this basis. And I think it's difficult for a regulator, provided your logic is sound, to give you too much hassle about it unless it's manifestly incorrect. Can a subsidiary located in the EU act as an EU rep? Yes, of course yes, absolutely can. On the basis of, here we go. This is one for Rohan. On the basis of our robust Information Technology Act, would India fall within the definition of countries with an adequate level of protection? Well, I can answer that actually, no, is the short answer. Maybe. Discussions are ongoing with Japan at the moment. Japan look likely to come on board. You may, I don't know. The answer is you're not at the moment. So it's not an assessment so much as it is a finding by the European Commission that India affords an adequate level of protection. So until you have that, you're not. And it's just a black and white. It's not a subjective assessment.
The question that, I mean, like as a corollary to that, has the regulator put out any kind of checklist type guidelines of what they would consider to be, providing adequate levels of protection at this stage? Yeah, or you're just supposed to comply with the GDPR, I mean, adopt the GDPR into your legislation?
No, and no to both of those questions. If you look at Canada, Canada is not it's not fully compliant. It's a completely different system to the GDPR, but the EU Commission regards it as affording overall an adequate level of protection. Same with various other countries. New Zealand, I think, was the last country to come on board, but that took 5 years to get that through right here. And the problem the UK is facing, the challenge the UK is facing, there's some guidance on this year, so we can't apply to the Commission to be afforded this status of adequacy until we become a third country. And we're not a third country until 29th of March. So 29th of March is going to be chaos. Unless something happens before then, we're going to be a third country in exactly the same position as India, which is slightly absurd in the sense that we implement the GDPR and we were one of the countries leading the negotiations on the GDPR, and we are arguably the most advanced in issuing enforcement actions on the GDPR and guidance on the GDPR. There's a huge amount of, if you go onto the ICO's website, Information Commissioner's Office, there's a huge amount of guidance which is very helpful. Where are we? What happens when a customer / EU resident posts his data on an Indian website for private? We answered that one, sorry. Does GDPR cover state surveillance? No, it doesn't. That's governed by something called RIPA, the Regulation of Investigatory Powers Act. There's a new one. There's a bill now, 2018 bill, currently before the Commons, which is causing an enormous amount of fuss and consternation, and it's just had some pushback on certain provisions, and has spawned a very popular BBC One television show called The Bodyguard, if anybody's interested, all about RIPA and stuff around that. So there are issues around that and the conflict with the European Constitution, but no, state surveillance is different. And if you, well, it's different. In the EU, it's done under sorry, there's two aspects to this question. The powers of the state to conduct surveillance and to monitor is done under separate legislation, if that was your question. And that's the Regulation of Investigatory Powers Act. The issues which arise for individuals do fall under the GDPR. In fact, that was what caused Safe Harbor to be struck down, because Edward Snowden and a chap called Maximilian Schrems said, hang on, our personal, well, Snowden didn't say this, Snowden said the NSA are snooping. And Maximilian Schrems said, hang on a second, when companies subscribe to the Safe Harbor, they say they're complying with the Data Protection Directive, but how can they be? Because the state has got access to this data and they're giving it, and they're not telling us the state has got access to this data. So it's a combination. So that is actually quite a good question, because there's two aspects to it. Next question. What is unambiguous consent? That is a very good question. What the definition of consent says, if you go back to your slides, it says an unambiguous indication of the data subject's wishes by which he or she, and this is the important bit to answer your question, Ashwarya, by which he or she, by a statement or by a clear affirmative action, so a positive action, ticking a box, signing a piece of paper, signifies agreement to the processing of personal data relating to him or her. So it's something active. It's very clear what the individual's consenting to. So it's certainly not an opt-out, most definitely an opt-in. But remember that there's 4 aspects to this. They need to be informed specifically, so there needs to be a very detailed privacy policy. Next question, sorry, I'm racing through this. If you collect data on EU residents and anonymize it, convert it into a de-identifiable form, so pseudonymization, would the data collector still have to comply with the obligations under the GDPR? Well, not if it's not personal data, is the question. Depends where you pseudonymize, where the pseudonymization, sorry, it's a difficult word for me, pseudonymization takes place. If it takes place at source, so that the transfer to the collector, you know, they de-identify it immediately, and then there's no way of reverse decompiling. It's not personal data, because remember, personal data is data which you can identify an individual either directly or indirectly. So directly, Alan Meneghetti, the lawyer from London, that's personal data. If it's gobbledygook, and you can't reverse the gobbledygook, so you can't reverse engineer it to work out that 64513 is me, then it's not personal data. Then it's just data.
I think that's.
You think that's it?
Yeah, I think I'm going to give.
Can I, but there's two more questions. I could
Go for it.
So let me very quickly, because I don't want to leave anybody unsatisfied. Can they have multiple DPOs? Yes, for different business units, you can, and for different jurisdictions. Yes, you could, but you should have one chief privacy counsel. Whether the financial data of Indian companies located in India without having an office in the EU, having their data stored on EU services, be collected without breaching the GDPR? No, because it's financial data, so it's not personal data. And secondly, I don't think that's a transfer into the EU rather than a transfer out. And I think that's it.
Great.
Thank you,
Alan. Thank
it's
you,
my
Yasmin.
pleasure. Thank you.
And yeah, that's been one more educational session. It's a pretty significant day, by the way, for us to have this webinar, because today is the day on which the decision of the Supreme Court on the Aadhaar, on the validity of Aadhaar has come out. So the Supreme Court has upheld Aadhaar, but has read down certain provisions and has struck down certain provisions of the Aadhaar Act. So it's an apt day to have a discussion on privacy.
Wow, okay, well that's very good. We timed it, of course.
Yes.
Yeah, of course, in conjunction with the Supreme Court.
Right. Yeah. All right, thank you everyone for attending, and goodbye. Till next time.